Mr. Nick, do we have Mr. Nix appearing from the display name starting with KMCI?
Yes.
All right, thank you. Call the case. All right. This is the state of Wisconsin versus Tommy Nix Jr., 25 CF 2636. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Tommy Nix appears by Zoom from Kettle Moraine Correctional, along with Attorney C. Joseph Antola from the State Public Defender's Office appearing in person. Mr. Nix, could you please give us a thumbs up if you have been given a copy of the criminal complaint? Mr. Nix has given a thumbs up. He's indicated he's received a copy of the criminal complaint. And Mr. Nix, current mailing address on there, 37 Sinekin Circle, apartment 307. Is that a good mailing address for you? You can give us a thumbs up or a thumbs down. He has indicated once again that is a good mailing address for him. We would stand mute as to any misdemeanor charges, waive formal reading of the complaint, and I am not able to confirm his eligibility for public defender services at this time.
Great. So, Mr. Nix, you have the right to have an attorney represent you in a case like this. Your eligibility for the public defender hasn't been determined. If you have an open case here with a public defender already assigned, that person should get assigned after you reapply. If you don't have an open case, it's a process that can take a while, a few weeks to a few months. So it's important to start that process as soon as possible, okay?
Okay.
I'm just looking through the complaint right now. Find probable cause in the complaint. What are the state's recommendations?
The state is seeking $5,000 cash, a ban from Golden Cars LLC and Kunes Auto Group. It's KUNES, and not to operate a motor vehicle. The defendant is currently in prison after being convicted of a plea elude on October 24th of this year. His maximum release date for that sentence is September of 26. He has a lengthy criminal history, including 3 total convictions for plea elude, 3 for omwalk, 1 for possession of a firearm by an adjudicated delinquent. In his cases, he has almost always been held in custody on cash bail or serving or a probation hold. At the time of this offense, he was already on felony bond in an omwalk case and on supervision. Given defendant's history, cash is necessary to assure appearance.
And you said it was Golden Cars LLC and Kunes?
Kunes, yes. KUNES.
Thank you. And on behalf of Mr. Nix?
First, I'll just start by asking Mr. Nix, without making any statements to the court, could you give me a thumbs up if you're okay with the conditions proposed by the state, and a thumbs down if you are not? And you are also okay with the cash bail? I can argue for less. Mr. Nix has indicated that he is fine with the non-monetary conditions and with the $5,000 cash bail. I would nonetheless still ask that the court consider a lower amount of cash bail. Simple reason being, the state in some ways made my argument for me. Mr. Nix is sitting in prison until at least, until up to September of 2026. I'm not sure how any cash bail right now is going to be assuring his appearance in court. He doesn't have a whole lot of freedom of movement as it stands. And, the state also mentioned that he is often sitting on cash bail on his cases. That suggests to me that he's often not able to post cash bail. $5,000 is a pretty high amount. I would, at the very least, ask the court to consider a lower amount of cash. Thank you.
All right. Any response to the state?
My understanding is the defendant has indicated he's okay with the bond amount as requested by the state.
All right. I think the amount requested by the state is appropriate. Given the allegations, Mr. Nix's criminal history is recited by the state. So I'll order $5,000 cash, a ban from Golden Cars LLC and CUNA's, and that Mr. Nix not operate a motor vehicle. I'll enter not guilty pleas on counts 2 and 3 regarding the time limits for the preliminary hearing, counts 1, 4, and 5.
Mr. Nix, do you have any strong opinions on waiving those time limits?
No.
Just given that, I would ask that we not waive time limits.
All right, we'll keep the time limits in place then, and we are adjourned. Thank you.
Next is Morgan Mask.
The MUE. Thank you.
Let me see. This, come on, you sound well.
Did I hear your last name is pronounced Miske?
Yes.
Very good. This is the state of Wisconsin versus Morgan Miske, 25 CF 2655. Can I have appearances, please?
Casey Dice appears for the state.
Morgan Miske appears in person in custody, represented by attorney Derek Brown. We have received a copy of the criminal complaint. Would waive its formal reading, stand mute to any misdemeanor charges. Would note that the address is correct.
All right. You have the right to have an attorney represent you at a hearing like this. And is Mr. Miske, you have an attorney here. We can give you the contact information for the public defender's office in case something happens. Just so you have it. Would you like that information?
Sure.
Okay. I find probable cause in the complaint. What are the state's recommendations?
The state's seeking a signature bond, no controlled substance or drug paraphernalia without a valid prescription, and no contact with CMS.
No objections.
And that's CMS as in the complaint.
Correct.
Okay. Given there's no objection, I'll order a signature bond. The condition that you're not use or possess any controlled substances or drug paraphernalia without a valid prescription, that you have no contact with CMS. I will enter not guilty pleas on counts 2 and 3 regarding the time limits for the preliminary hearing for count 1.
We would waive time limits.
Okay, we'll waive time limits for the preliminary hearing, and we are adjourned. Thank you.
If I did this, Brandon Russell. Thank you. Thank you. Russell, Brandon Russell. 70 OX.
This is the state of Wisconsin versus Brandon Russell, 25 CF 2659. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Russell appears with counsel Merle Josty. Good afternoon.
Good afternoon. Have you received a copy of the complaint?
We have,
Will you waive its reading?
yes.
And is Mr. Russell eligible for a public defender?
He's retained me already.
Okay. So we can give you information about the public defender, just so you have that contact information. Otherwise, you've got your attorney with you here today. Would you like that information?
I don't need that information.
Okay. I find probable cause in the complaint. What are the state's recommendations?
The state's asking for $5,000 cash. There are a variety of Act 3 eligible offenses charged here. The state views it has a strong case. Many of the charges are accompanied with photos of the injuries. We're also asking for no contact with Chang R. If the defendant were to post, we'd ask for pretrial services with GPS monitoring. We're also asking for a ban from the 8300 block of Inverness Drive in Madison. Inverness is spelled INVERNESS. Nothing further.
All right, and that's Chang, CHANG.
Correct.
On behalf of Mr. Russell.
We'd ask for a signature bond at this time. There is a pending case already that's been filed against my client. 25 CF 2510 was filed on November 4th, 2025. In that case, he was given a signature bond. He has not violated, and there's no allegations of him violating any of the conditions of that bond, which already included a no contact and a ban from the family residence on Inverness that was already listed. It appears in this case, it's somewhat unusual that even though he was arrested on that date and charges were filed on November 4th and given a signature bond, law enforcement had, I guess, subsequent follow-up with Chang, his wife, about a week later. And at that time, she's made these allegations, which have resulted in this new case being filed. He was arrested when he went to the residence with his mother and also with a law enforcement officer to retrieve property on Thursday, late afternoon, early evening last week. And that's when he was told that law enforcement had probable cause for his arrest based on incidents that had occurred prior to the last arrest at the beginning of November. I don't think anything has fundamentally changed in terms of Mr. Russell's willingness to make his appearances for court or his risk in the community. I think it's unusual to have somebody arrested when they're already on bail based on events that occurred prior to those initial charges being filed. This is certainly something that law enforcement or the DA's office could have given him a summons date. He could have appeared out of custody. He was already making all of his court appearances. These are essentially late disclosures. And so I don't think anything has really changed in the nexus that you're to consider in terms of whether or not cash is necessary. He already went out, retained a lawyer, made his court appearances, and has abided by the conditions of bail that were in effect almost for the last 3.5 weeks at this point. So we'd ask for a signature bond. My client has lived in the Madison area for the last several years. He moved here after he completed his undergraduate degree. He works at Epic. He travels quite a bit for work, as many people at Epic do, when he goes to various sites to help hospitals go online with the Epic products. He has no prior record. He has no history of missing court dates. And as I indicated, most importantly, he's abided by all of those no contact conditions since they were imposed upon him earlier this month. For all those reasons, we're asking for a signature bond. These parties are going to be filing for divorce very soon. I know that Mr. Russell and his family were in the process of attempting to retain a family law attorney on Friday last week.
Okay, do you say there was a signature bond issued in 25 CF 2510?
Yes.
Okay, I see that.
I'm seeing cash.
I'm seeing cash as well. It was posted couple days after it was ordered.
750.
Yep.
Right, yeah.
I'm sorry, maybe I was looking at my notes from the misdemeanor case.
Okay, and then in that case, it looks like there's some dates we need to get straightened out too. I see in 25 CF 2510, the alleged incident date is November 2nd, 2025. And then there's the initial appearance that was held November 4th, 2025. This 25 CF 2659, the instant case, has an offense date for the first 3 counts on November 10th. Oh, I see 2024. That's where my confusion was. All right. All right, I'll take the state's response.
Well, Your Honor, clearly cash was determined to be appropriate a few weeks ago when it was considered perhaps a one-time incident. We now are seeing that he has a history of this. I would also note he recently entered into a DPU on the misdemeanor case, having pled guilty in the DPU fairly recently, likely before all of this became known to our office. Clearly, cash is necessary as previously determined by the court. We would renew our request for $5,000 given the, now 3 cases with the same victim, the same kind of ongoing course of conduct.
All right, thank you. So I'll enter not guilty pleas as to the misdemeanors. I do think some cash is appropriate here. Though I think a lower amount than what's recommended by the state is appropriate. So I'm going to order $750 cash. I'm going to order that Mr. Russell have no contact with Chang R. Except through the court system. So if you're in court for like a divorce proceeding, you'd be able to speak with Chang R. But outside of that, no contact, okay? I'm going to order pretrial services with GPS monitoring to enforce the ban from the, I believe it was the 2300 block of Inverness Drive.
8,300.
8300 block of Inverness Drive. I'll order that you report there by 10 o'clock of the next business day. If you can make it today, you should make it today, because there should still be time to get over there today, okay?
Okay.
All right. In regards to the time limits for the prelim on the felonies,
We can waive that and ask for status.
we'll waive the time limits for the preliminary hearing then. Is there anything else I can do for the parties?
No.
No.
Okay, then we are adjourned. Thank you.
Right, so service. Next is WALNER Martinez-Castellanos. Right now I'm looking at January 26th. 120 for seven. Then Attorney Anderson, I do have like a complaint for your client now. Thank you.
January 26th at 1:30. 1:20.
You made it.
Okay.
Here.
And Mr. Svensson, it looks like there was an interpreter requested for the live stream as well. Do you need an interpreter, sir?
Let me see, take that as my name. The interpreter will be interpreting consecutively that from up here.
Okay. This is the state of Wisconsin versus WALNER Martinez-Castellanos, 25 CM 2803.
Es el estado de Wisconsin contra WALNER Martinez-Castellanos. Este es el estado de Wisconsin contra WALNER Martinez-Castellanos, 25 CM 2803.
Appearances.
Comparecencias.
Casey Dice appears for the state.
Casey Dice de parte del estado.
Mr. Walner Martinez Castellanos appears in person and in custody alongside Attorney C. Joseph Antola from the State Public Defender's Office.
El acusado WALNER Martinez-Castellanos comparece preso de la cárcel en la sala de audiencias con su abogado C. Joseph Mentola.
We have received a copy of the criminal complaint
Hemos recibido copia de la denuncia criminal.
Due to the language barrier, I would ask that it be read to Mr. Martinez-Castellanos.
Debido a la barrera de idioma, quisiera pedir que se lea al señor Martínez Castellanos.
Count one is misdemeanor battery with a domestic abuse assessment.
Cargo número 1 es agresión, delito menor, y un costo adicional por ser un caso de abuso doméstico.
That count alleges that on or about Thursday, October 30th, 2025, in the city of Madison in Dane County, Wisconsin, that you did cause bodily harm to BEM by an act done with intent to cause bodily harm to that person without that person's consent. That's a Class A misdemeanor, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 9 months or both.
En este caso, se alega que el día jueves 30 de octubre de 2025 en la ciudad de Madison, en el condado de Dane, en Wisconsin, usted ocasionó daño corporal a BEM con la intención de causarle ese daño corporal a esa persona sin el consentimiento de esa persona, y esto es un delito menor de clase A, y al ser condenado por este cargo puede resultar en una multa de $10,000 o prisión por hasta 9 meses o ambos.
And further, because this charge is an act of domestic abuse, the court shall impose the domestic abuse assessment of $100 for this offense, because this is an enumerated crime and the conduct constituting the violation involved an act by the defendant against his or her spouse, against an adult with whom the defendant resides or formerly resided, or against an adult with whom the defendant has created a child.
Y además, por las provisiones de los estatutos del estado de Wisconsin, como este es un acto de abuso doméstico, la Corte tiene que imponer una evaluación adicional de $100 por esta ofensa, como este caso es un cargo enumerado en los estatutos del estado y constituye la violación de un acto contra el cónyuge del acusado o contra un adulto con quien el acusado había vivido, residido, o contra otro adulto con quien el acusado tiene un hijo menor.
Count two is disorderly conduct with a domestic abuse assessment.
Cargo número 2, conducta desordenada, un caso de abuso doméstico.
That count alleges that on or about Thursday, October 30th, 2025, in the city of Madison in Dane County, Wisconsin, while in a private place, that you engaged in violent, abusive, indecent, profane, boisterous, unreasonably loud, and or otherwise disorderly conduct under circumstances in which such conduct tended to cause a disturbance. That's a Class B misdemeanor, and upon conviction, you may be fined not more than $1,000 or imprisoned not more than 90 days or both.
En este caso, se alega que el acusado el día jueves 30 de octubre de 2025 en el pueblo de Madison, condado de Dane, en Wisconsin, mientras en un lugar privado, sí participó en un comportamiento violento, abusivo, indecente, vulgar, bullicioso, ruidoso o de otra manera desordenada bajo circunstancias que provocaron un disturbio, algo que está en contra de los estatutos, es un delito menor de clase B y al ser condenado por este cargo puede resultar en una multa de $1,000 o prisión por hasta 90 días.
That count also carries with it the mandatory $100 domestic abuse assessment.
Este cargo también tiene con sí la multa adicional de $100 por ser un caso de abuso doméstico.
Count three is misdemeanor bail jumping with a domestic abuse assessment.
Cargo número 3 es quebrantar condiciones de fianza previa, también un caso de abuso doméstico.
That count alleges that on or about Thursday, October 30th, 2025, in the city of Madison in Dane County, Wisconsin, having been charged with a misdemeanor and having been released from custody, that you intentionally failed to comply with the terms of your bond, to wit, that you intentionally that you had contact with BMD contrary to that bond. That's a Class A misdemeanor, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 9 months or both.
Se alega en este caso que el acusado el día jueves 30 de octubre de 2025 en la ciudad de Madison, en el condado de Dane, en Wisconsin, después de ya haber sido acusado de un delito menor y sido liberado bajo de la custodia de la cárcel, intencionalmente falló en cumplir con los términos de la fianza previa. Fue liberado con condiciones de no tener contacto con BMD. Se alega que sí tuvo contacto con BMD y al ser condenado por este cargo puede resultar en una multa de $10,000 o prisión por hasta 9 meses.
That count also carries a mandatory $100 domestic abuse assessment upon conviction.
Este caso también puede llevar una multa adicional de $100 por ser un caso de abuso doméstico.
I can confirm at this time that Mr. Martinez-Castellanos is eligible for public defender services.
Puedo confirmar en este momento que el señor Martínez Castellanos sí califica para los servicios del defensor público.
I would also be moving to dismiss count 3.
También estaría dispuesto a pedir que se desestime cargo número 3.
Count 3 says that his bail conditions were to have no contact with a person identified as BMD.
Cargo número 3 indica que él estaba bajo condiciones de fianza de no tener contacto con una persona con iniciales BMD.
And the complaint identifies the alleged victim as BEM and provides no indication that BEM and BMD are the same person.
En la denuncia se alega que no debe tener contacto con la víctima en ese caso con iniciales BEM. No hay nada que indica que BEM y BMD es la misma persona dentro de las denuncias.
And so just based on the sufficiency of the complaint alone, I believe count 3 has to be dismissed.
Entonces, basado en la suficiencia de la denuncia, pienso que cargo número 3 debe ser desestimado.
Any response to the state on the motion to dismiss count 3?
¿Alguna respuesta de parte del Estado sobre el pedimento para desestimar cargo número 3?
Your Honor, BEM and BEMD are the same person, as is common with folks, particularly in the Spanish community or other communities. They often have two last names. This person's first name is B, their middle initial is E, their last names are M, D. It's a notice pleading state. The defendant, it's a notice pleading state. The defendant is clearly on notice as to who this person is, who he was to have no contact with.
Entonces, la persona con iniciales BEM es igual a la persona con iniciales BEMD. Como ya se reconoce comúnmente, gente hispana tiene dos apellidos y los iniciales de esta persona, el nombre empieza con B, segundo nombre con E y los dos apellidos M y D. Este es un estado donde se avisa de procedimientos y el acusado ha sido notificado de los iniciales de la víctima en ambos casos.
Is that all from the state then?
Eso es todo del Estado.
As to the motion.
Yes.
Sobre el
Yes.
pedimento.
I'll give you the last word on the motion to dismiss.
Entonces le doy la última palabra sobre el pedimento para desestimar el cargo.
I understand the state's representation, but the simple fact is the complaint does not establish that BEM and BMD are the same person. Those facts are not alleged.
Bueno, entiendo la postura del Estado, pero en las denuncias no se alega que estos iniciales son de la misma persona.
Certainly sloppy drafting by the state, but there is a reasonable inference within the four corners of the complaint that BEM and BMD are the same person.
Se ha escrito un poco mal por parte del Estado, pero se puede hacer una inferencia razonable dentro de las cuatro esquinas de la denuncia que las iniciales BEM y BMD conciernen el mismo individuo.
The initials section of the complaint on the last page, page 404, states the second paragraph of that. two-sentence paragraph states, the individual identified herein as BEM is the same person identified as BMD in the bond conditions reference Dane County Circuit Court case numbers 25 CM 1558.
Good catch.
Se puede indicar que en la porción de iniciales dentro de la denuncia, en la cuarta página, la página 4 de 4, en el segundo párrafo, se indica ahí mismo que el individuo identificado por dentro de esta denuncia con iniciales BEM es la misma persona a la persona identificada con iniciales BMD en las condiciones de fianza en el caso del condado de Dane 25 CM 1558.
All right, so I'll deny the motion to dismiss.
Así que voy a negar el pedimiento para desestimar cargo número 3.
I missed it, Mr. Martinez-Castellanos, you have the right to have an attorney represent you in a case like this.
Y señor Martínez Castellanos, usted tiene derecho a ser representado por un abogado en un caso tal como este.
You are eligible, if you have an attorney appointed through another open case, that same person should get appointed to this one.
Usted sí califica para un defensor público. Si uno ha sido asignado en el otro caso, debes pedir que ese mismo abogado sea asignado en este caso.
Consequently, I find probable cause in the complaint. What are these state's recommendations?
Determino que hay motivo fundado dentro de la denuncia criminal, que son las recomendaciones del estado de fianza.
The state's asking for $2,000 cash. No contact with Brenda MD. A ban from the 200 block of North Thompson Drive in Madison.
El estado quisiera pedir una fianza de $2,000 de dinero en efectivo con condiciones de no tener contacto con Brenda MD, que no esté en la cuadra 200 de la norte de la Thompson.
No alcohol. Did you get that?
Y que no consuma alcohol.
All right. If he were to post, we'd ask for GPS monitoring. I do recognize this is likely moot, as he was here 4 days ago and got $20,000 on what was his third case against this victim. Today is his fourth case against this same victim.
I'm sorry, did you say he got $20,000?
$20,000 cash bond.
20.
20.
Entonces, tal vez todo esto se queda sin tener que decir, pero también quisiera que si él paga la fianza en este caso, que se instale un aparato GPS con una tobillera. Tal vez todo esto es sin tener que decir porque él estaba aquí hace un par de días en el tercer caso contra la misma víctima y se determinó que se debe tener una fianza de $200,000. Este es el cuarto caso contra la misma víctima.
I'm sorry, I just have a question for the prosecutor. Are you also asking for a no alcohol? I don't believe that was requested initially, but I heard Ms. Simon discuss it with you.
Y también está pidiendo usted no tener una condición de no tener alcohol. Escuché que el procurador habló de eso después, pero no se había indicado inicialmente.
Yes, and I apologize if I left it off on my first reading of the bond conditions.
Sí, pido disculpas que lo dejé sin decir en mi primera lectura de las condiciones de la fianza.
On behalf of Mr. Martinez-Castellanos.
Y de parte del señor Martínez Castellanos,
I'm just going to take 1 minute to speak to him. I speak Spanish, so.
voy a tomarme un momento para hablar con él. Yo hablo español, así que voy a hablar con él.
We're not going to be objecting to any of the non-monetary conditions. Would be asking for a signature bond on this case. Ultimately, I have not been able to verify any criminal convictions for Mr. Martinez Castellanos.
Bueno, no nos vamos a oponer a las condiciones no monetarias que pidió el Estado, pero quisiera pedir una fianza de promesa, cumplir con esas condiciones. No he logrado verificar que ya existan algunos cargos criminales o antecedentes penales contra el acusado.
Would also note, as the state did, he has a $20,000 cash bail already. He cannot post that. He cannot post. He's not posting cash is what I'm trying to say.
También se puede anotar que él ya tiene una fianza de $20,000 en el caso anterior. Él no va a poder pagar esa cantidad, no va a poder pagar ninguna cantidad de dinero en efectivo, se puede decir.
I spoke to him and he represented to me that he has been looking for work and that the most recent work he did never even paid him.
He hablado con él y él ha estado buscando trabajo. En su último trabajo nunca le pagaron.
Just double checking my notes.
Estoy verificando mis notas si hay algo más.
No, nothing further. Thank you.
Nada más, gracias.
Any response from the state?
¿Alguna
No.
respuesta del Estado? No.
All right. So I'll enter not guilty pleas to each of the counts.
Voy a indicar en el acta declaraciones no culpable ante los cargos.
I'll order $2,000 cash.
Voy a hacer una orden de una fianza de $2,000 de dinero en efectivo.
No contact with Brenda M.D.
Ningún contacto con Brenda M.D.
Banned from the 200 block of North Thompson Drive.
Una prohibición de estar en la cuadra 200 norte de la Thompson.
Condition that Mr. Martinez-Castellanos not use or possess any alcohol.
Y otra orden que el señor Martínez Castellanos no tenga en su posesión ni usa alcohol.
And that before he is released, he's to be fitted with GPS and pretrial services will monitor his location and his no alcohol condition.
Y antes de ser liberado que le instalen un aparato GPS que sea monitoreado en su ubicación y el uso de alcohol. Y respeto a su uso de alcohol.
I believe that's all I can do for the parties today. So
Pienso
we
que
are
es,
adjourned.
eso es lo único que puedo hacer para las partes hoy día. Estamos concluidos.
Thank you.
Thank you.
Next is Gabriel Albrecht.
That was it for the interviews.
That's true. Yep, all right. Oh, yeah, that was it.
Thank you. And how do you spell your client's last name?
It's Gabriel Albrecht. It was added well after.
Okay.
Yeah, let's see it.
Sorry, put me through the wrong.
This is the state of Wisconsin versus Gabriel Albrecht, 25 CM 2804. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Gabriel Albrecht appears in person in custody with counsel attorney David Anderson. We have received a copy of the complaint. We do waive any further reading. Ask the court to enter not guilty pleas on my client's behalf, and the address is correct. The address is correct.
You have the right to have an attorney represent you in a case like this. You have Attorney Anderson appearing for you today. We can give you information on how to contact the public defender, just so you have that in case something happens. Would you like that information?
If he needs it, I can provide it.
Okay, very good. I find probable cause in the complaint. What are the state's recommendations? Oh, that's okay. All right, do we have somebody who identifies as a victim in this case who would like to make a statement? If so, please unmute and identify yourself.
Yes, my name is Ebony Morgan. I am the partner in the situation.
Okay, and can you spell your name for the record, please?
Yes, it's E, B as in boy, O, N as in Nancy, I, last name Morgan, M as in Mary, O, R, G, A, N as in Nancy.
I have EBONIMORGAN. Is that correct?
Correct.
Okay, and what would you like me to know for the hearing today?
I would like to know, Your Honor, first of all, I want to address you and thank you for your time. And I want everyone to know that this was a domestic dispute that escalated between two irresponsible parties, myself and Gabriel. I called the police to stop the escalation. Both of us needed to be stopped at that time. I understand the law is that somebody has to be removed from the home, and I respect that. I do not believe Gabe is a threat to myself or my children. I do know that we made a mistake that night and someone had to be removed. I do not think that any other further penalties need to be caused against him. He's a good father, he's a good provider. We just made a mistake, and I want the court to take that into consideration.
Thank you. And the state's
Sure.
recommendation?
State's asking for a signature bond, no acts or threats to Ebony M, no drinking.
Any objection?
No objections.
All right. And I'll order a signature bond with the conditions that Mr. Albrecht make no acts or threats of violence to Ebony M, and that he not use or possess any alcohol or use or consume any alcohol. No, I was right the first time.
Excuse me, can I ask a question, Your Honor?
You may,
If
but
we live together. I just want to be clear. So if we live together and I have alcohol, will he be in trouble? That's what I just want to be clear.
probably. It depends. I can't, I don't know your situation, so I can't tell you definitively. But if it's an area that he has access or control over, then yes,
Okay,
it would be a
Thank you.
problem. Okay,
thank you.
I'll enter not guilty pleas as to each count. Did I miss anything, Attorney Dice?
No.
Attorney Anderson?
No, thank you.
Okay, then we are adjourned. Thank you.
Next is Jordan Sharlow.
Did you see that at him?
No.
How you gonna four corner without reading four corner?
I control F'd it and somehow I didn't see it.
Rather have somebody look than not look. Oh,
Yeah,
I do appreciate you bringing it up.
yeah, because I was like, I mean, the whole time I was like, what is going on here?
I'm sorry, we have Mr. Jordan Sharlow?
Correct.
This is the state of Wisconsin versus Jordan Sharlow, 25 CF 2660. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Jordan Sharlow appears in person and in custody alongside attorney C. Joseph Fantola from the State Public Defender's Office. We have received a copy of the criminal complaint. We would waive its formal reading. One moment. I can confirm that the mailing address on it is correct. And I can confirm at this time he is eligible for public defender services.
You have the right to have an attorney represent you on a case like this, sir. You are eligible for the public defender, so hopefully they get somebody appointed to you sooner rather than later. Before you get to the victim, I'll start by noting there was a PSA filed in this case. Has the new case listed as 3 out of 6 on the new criminal activity scale, a 2 out of 6 on the failure to appear scale. Considers the current offense violent. It notes there were no pending charges at the time of the offense. Notes that Mr. Sharlow has a prior misdemeanor conviction, but no prior felony convictions, no prior violent convictions, and no prior failures to appear within the past 2 years. Does note that he did have a prior sentence to incarceration. It recommends cash, pretrial supervision. If there's somebody who identifies as a statement in this case, if there's somebody who identifies as a victim in this case who would like to make a statement, please unmute and identify yourself.
My name is Tiaja Johnson.
All right. And can you spell your first and last name, please?
First name is Tiaja, T'_IOZJA. Last name Johnson, JOHNSON.
And what would you like me to know today?
I would like to let you know that I don't feel like that they should be out at all, especially him, due to the fact that he has 3 intentional homicide cases against him, and he had a case in Illinois around about the same thing. And I feel like he should not be let out to the public. He's not. The public is not safe when he's out because he's a murderer.
All
And
right.
that's it.
Thank you. What are the state's recommendations?
The state's requesting $500,000 cash, no release except to Dane County Pretrial Services during business hours for fitting with a GPS monitoring bracelet, no weapons, no ammunition, 24-hour house arrest if released on bail, with no travel outside of the residence except to court appearances or for purposes of emergency medical care or as pre-approved by Dane County Pretrial Services. No contact with either of the co-defendants, it's Donta Collins or Justin Sharlow. No contact with the immediate family members of Darius H., David E., or Ricardo S. These are, of course, Act 3 eligible offenses, and the homicide charges here relate to a series of shootings and killings following April 19th, 26 homicide of Martez Moore at O'Grady's Tavern on Mineral Point Road. In each of the 3 homicides, Jordan Sharlow targeted persons associated with a rival faction and was involved in their murder. Justin, his co-defendant, is linked only to the Sims homicide in July of 2017. Jordan is linked to all 3 homicides. Jordan Sharlow was initially charged with Edwards homicide in 2018. The state dropped the case because of witness issues, as well as the fact that Jordan and Justin were being extradited to Cook County, Illinois, and charged with a homicide there. At some point, due to pretrial delays, Jordan and Justin Sharlow were released from custody. After they were released from custody, a key witness in the Cook County homicide case was murdered in Crest Hill, located in Will County, Illinois, in April of 24. Cook County dropped its homicide case after that witness was murdered. The Crest Hill case remains open, and the Crest Hill Police Department participated in last week's arrest of the Sharlows based on evidence linking them to the Crest Hill homicide. It's unknown at this time if Cook County State Attorney will be seeking to re-indict on the original Illinois homicide based on potential admissibility of the dead witness's statements under the doctrine of forfeiture by wrongdoing. Jordan Sharlow had a bench warrant for his arrest in 2011 CM 674 and 2011 CM 2806 on January 26th of 2012, November 30th of 2011, and on May 11th of 2011. Jordan Sharlow's priors include disorderly conduct from 2012, bail jumping, misdemeanor level from 2012, carrying a concealed weapon from 2018. Given the seriousness of the charges, links of the defendants to 2 homicides in Illinois, including the targeting of a witness, the state believes the cash bail is appropriate and the conditions we're recommending are appropriate.
Thank you. On behalf of Mr. Sharlow.
I would just ask for 1 minute to speak to him.
What's the second no contact notice with Darius?
I'm gonna need all of them and their names spelled again. Good.
Sure.
And then before you go, Attorney Ventola, I'm gonna have the state go through its recommendations again, just so we're all on the same page? Because
It was a long list.
Attorney Dice.
$500,000. Pretrial services with GPS monitoring during business hours. No weapons, no ammunition. 24-hour house arrest. No travel outside the house except to court appearances, emergency medical care, or as pre-approved by pretrial services. No contact with co-defendants, and that would be Jordan Sharlow, as well as Donta Collins. Donta is spelled D-O-N-T-A, last name Collins, C-O-L-L-I-N-S. No contact with the immediate family member of the three victims. Darius H. Darius is spelled D-A-R-I-U-S. David E. Common spelling for David. Or Ricardo S. Ricardo is spelled R-I-C-C-A-R-D-O. I believe that's it.
Okay. On behalf of Mr. Sharlow.
We're not going to be objecting to any of the non-monetary conditions, but I think I should make clear that when we're talking about $500,000 cash bail, a list of conditions this extensive is just window dressing. $500,000 is not an amount that someone who qualifies for public defender services is going to be able to post in this lifetime or the next. It's a pretty extreme amount of bail, and the state is well aware that there are mechanisms that they can use to request that Mr. Sharlow be held without bail. Because they have not used those mechanisms, a bail has to be set at an amount that is reasonable. Ultimately, I understand these are very serious charges. The court is going to impose pretty significant cash bail, so I'm going to ask that a few things be considered. On the point of the Illinois homicides, it's my understanding from talking to Mr. Sharlow and from what the state has said, that those charges are not even pending right now, that those were dismissed, that the state might refile in Illinois. But right now, I do not believe, based off of what I've heard, that there are pending homicide charges against Mr. Sharlow in Illinois. He remains innocent until he's proven guilty of those cases, of this case. And then from there, he has really significant ties to Dane County. He is 34 years old. He's lived here his entire life. He has 6 children, the youngest of whom is 3 weeks old. That child lives with him. Also, the fact is, with the extent of the conditions proposed by the state, GPS monitoring, total home confinement, an extensive list of geographic bans, no weapons conditions, $500,000 cash almost seems unnecessary to assure his appearance in court. I understand the court is still ultimately going to consider public safety. I would ask that cash be set in an amount of tens of thousands of dollars as opposed to hundreds of thousands, given these facts. Thank you.
I disagree with the state. I think the amount is too low. Given not only what's alleged, but the history here, there's an extreme danger, not only to public safety, but public process. I'm going to set bail in the amount of $1 million. I'm going to order the conditions as recommended by the state. I can go over what I have for those conditions again, if you'd like, Attorney Ventola.
That's not going to be necessary.
Okay. In regards to the time limits for the preliminary hearing?
I just need 1 minute to speak to him.
Yep.
Will not be waiving time limits. Thank you.
Okay, we'll keep the time limits then, and I should have responded to your argument about just pulling bail. I don't make any presumptions about how much somebody can or can't pay. I just know that given what's alleged and kind of the structure of the case, or not structure, the arguments in court today, that if Mr. Sharlow can post, I think $1 million is a reasonable amount. For some people that may not be a lot. For most people, almost everybody. I know it is a very high amount. So we'll keep the time limits in place then, and we are adjourned. Thank you. I'll need a quick minute. This is the state of Wisconsin versus Justin Sharlow, 25 CF 2661. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Justin Sharlow appears by Zoom from the Dane County Jail alongside Attorney C. Joseph Antola from the State Public Defender's Office, appearing in person. Mr. Sharlow, can you give me a thumbs up if you've been given a copy of the criminal complaint? He is indicating that he has received a copy of the criminal complaint. And can you indicate if the listed mailing address on the criminal complaint is a good place for you to receive mail? And he has indicated it is a good place for him to receive mail. We would waive formal reading of the complaint. I can confirm at this time that he is eligible for public defender services.
You have the right to have an attorney represent you in a case like this, sir. You're eligible for the public defender. They'll work on getting somebody appointed to your case as soon as possible. But that's a process that can take some time. I'll begin by noting there was a public safety assessment filed in this case. It lists this case as a 2 out of 6 on the new criminal activity, a 2 out of 6 on the failure to appear scale. It considers the current offense violent, but it notes that there were no pending charges at the time of the offense. Notes that Mr. Sharlow has a prior misdemeanor conviction, but no prior felony conviction. He has one prior violent conviction, but no prior failures to appear. It recommends cash bail. We have somebody who identifies as a victim in this case. Can you please unmute and identify yourself? Does somebody identify as a victim in this case? And would they like to make a statement?
Hello, my name is Tiaja Johnson, still the same person.
Okay, and just so the record's clear, can you state and spell your first and last name?
Yes, a first name is T''IOZJA. Last name Johnson, JOHNSON.
And what would you like me to know?
I would like to know, just as his brother, they are not good to come out into the world. They're horrible men. They have all these murder charges against them, and all they're going to keep doing is just killing, and killing. So he should be locked up in that cell like he is now and stay there for the rest of his life and rot in there.
Thank you. What are the state's recommendations?
Your Honor, the state's asking for conditions that mirror those that were just given to his co-defendant Jordan Sharlow. That would be $1 million cash bond, no release except to Dane County pretrial services during business hours for fitting with a GPS monitoring bracelet, no weapons, no ammunition, 24-hour house arrest. If released on bail, no travel outside the residence except to court appearances for purposes of emergency medical care or as pre-approved by Dane County Pretrial Services. No contact with co-defendant Jordan Sharlow, as well as Donta Collins. No contact with the immediate family of the victims. In all these cases, that's Darius H., David E., or Ricardo S. The defendant is charged with an Act 3 offense. The homicide charges for this defendant, as well as his co-defendant, relate to a series of shootings and killings following the April 19th, 26 homicide of Martez Moore at O'Grady's Tavern on Mineral Point Road. These were the retaliation homicides. Jordan is charged with 3. Justin is charged with it being involved in 1. As I alluded, or as I talked about it just minutes ago, Jordan was initially charged in the Edwards homicide in 2018. The state dropped that case because of witness issues, as well as the fact that Jordan and Justin were being extradited to Cook County, Illinois, and charged with a homicide there. At some point, due to pretrial delays, Jordan and Justin Sharlow were released from custody. After they were released from custody, a key witness in the Cook County homicide case was murdered in Crest Hill, located in Will County, Illinois, in April of 24. Cook County later then had to drop its homicide case after a key witness was murdered. The Crest Hill case remains open, and the Crest Hill Police Department participated in last week's arrest. Justin Sharlow had missed court dates in 2010 CM 3098 on August 22nd of 2012 and in 2017 CM 2285 on June 11th of 2018 and February 13th of 23. Justin Sharlow's prior offenses include disorderly conduct and criminal damage to property in 2012 and battery in 2013, possession of THC and drug paraphernalia in 2015. And given the seriousness of the charges, the links of the defendants to 2 homicides in Illinois, especially including the targeting of a witness to that homicide in an effort to do what happened, right? To interfere with the ability for Illinois to prosecute the case, the state believes the cash bail and the recommended conditions are appropriate. Your Honor, I understand the court may be tempted to, this defendant is charged with 1 homicide, his co-defendant is charged with 3 homicides. Your Honor, I would ask for bond to be in the exact same amount for both co-defendants.
On behalf of Mr. Sharlow.
I'll give kind of an abbreviated version of my previous arguments. $1 million is a very high amount. Mr. Sharlow qualifies for public defender services. I don't think there's any expectation that someone who qualifies for public defender services could post $1 million. The Illinois cases, as I mentioned previously, remain unproven. Mr. Sharlow innocent until proven guilty on this case, on every single case, and he has lived in Dane County his whole life. He has, it appears, just about his whole family here in Dane County. And lastly, I would note, as the state did, Justin Sharlow is only charged in 1 of the homicides. Given that, I do believe a lower amount of cash would be appropriate, maybe $100,000. But $1 million does seem to be quite a bit when the court imposed $1 million on someone charged with 3 homicides.
Your Honor, if our concern is him getting out of custody and killing key witnesses to the prosecution, I don't think it's relevant whether he's charged with 1 homicide or 3 homicides. I'd ask for $1 million.
And Mr. Sharlow has never been proven to have killed any witnesses.
Yep. It does change the chance of the state getting a conviction, whether the state gets a conviction on 1 count or 3. It'll lead to the same result, but ultimately with 3 counts, the state has 3 chances. With 1 count, the state only has chance, probably isn't the right word, but I think we all know what we mean when I say that 1 bite at the apple. I'm going to order $850,000 cash with the conditions as recommended by the state. Mr. Sharlow, would you like me to recount those conditions? If so, give me a thumbs up. If not, you can, okay, I see a thumbs down. So Mr. Sharlow is aware of the conditions. In regards to the time limits for the preliminary hearing,
We will not be waiving time limits.
we'll keep the time limits in place then, and we are adjourned. Thank you.
Next is Travis VIAL. Travis VIAL. It works.
This is the state of Wisconsin versus Travis VIAL, 25 CF 2662. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Travis VIAL appears in person and in custody alongside attorney C. Joseph Ventolo. We have received a copy of the criminal complaint. One moment, please. Okay, can confirm that the mailing address on it is correct. We would waive formal reading of the complaint, and I can confirm at this time that Mr. VIAL is eligible for public defender services.
Mr. VIAL, you have the right to have an attorney represent you at hearings like this.
One moment, I just gotta explain something to him.
Okay.
We're good to proceed. Thank you.
Very good. You have the right to have an attorney represent you at a hearing like this. You're eligible for a public defender. You don't already have an attorney appointed on a separate case, public defender. They'll work on getting somebody appointed for you. It's a process that can take a few weeks and also take a few months. I'll begin by noting there was a PSA filed. I find probable cause in the complaint. There's a PSA filed listing, this case is a 4 out of 6 on the new criminal activity, a 5 out of 6 on the failure to appear scale. Notes that the current offense isn't violent. There were no pending charges at the time of the offense. There are prior misdemeanor and felony convictions, no prior violent convictions, but 2 or more failures to appear in the past 2 years, failures to appear older than 2 years old, prior sentence to incarceration, recommends modest cash bail, and reporting to and complying with pretrial supervision. What are these state's recommendations?
In line with that, the state's recommending $1,000 cash. We have failures to appear from July of 25, 2 of them in July of 25, May 27th of 25, April 9th of 25, February 18th of 25, August 15th of 22, et cetera. He's had cash bond before. He's missed court and had to forfeit bond in his last several cases. Also, as a condition, I think Dane County pretrial services makes sense if he's able to post, as well as no drug paraphernalia.
Pretrial services for drug monitoring.
Correct.
And Attorney Ventola?
No, I'm not a party on probation.
You can speak with your client if you need to, but
One
Monday.
moment. Well, I will second what he said. He is on probation, so he is already being monitored. I checked to see if there was a probation hold on him. It looks like they had placed one and then they dropped it. But we would be asking for a signature bond at this time. Not going to object to the non-monetary conditions. At the end of the day, upon reviewing this complaint, we're talking about 1/10 of a gram of meth. I don't want to speculate too much, but given Mr. VIAL's history, it does appear that addiction is a recurring issue for him. You know, there's no indication that the present offense is violent. There's no indication that he's selling or moving significant amounts of drugs. We're talking about 1/10 of a gram of methamphetamine. That is to my understanding, from, you know, my work experience, the smallest denomination that drugs are sold in for personal use. You know, given the really small amount of drugs involved, and given that this does appear to be an addiction case, and given that he's already being monitored through probation, I think a signature bond would be appropriate here. Thank you.
Okay, any response from the state?
Well, Your Honor, the defendant was found slumped over in his van at Quick Trip and police were needed to respond. The defendant was found with a needle in his arm, passed out. So however much drugs were not yet in his body, might be minimal, but clearly probation isn't working for this defendant. Clearly, he needs something else to keep from using and possessing drugs.
If I may, just briefly.
Yes.
You know, if there are addiction issues here, then cash bail is just not going to fix that. And probation can help, pretrial services monitoring can help, but ultimately, you know, cash bail is not going to be not going to help someone who's been deemed indigent, you know, stay clean. And the purpose of cash bail is, given that this is not Act 3 eligible, is to assure his appearance in court. Thank you.
Very good. Well, it looks like in the past there have been problems securing Mr. Vial's appearance in court, and if there are addiction issues, that's going to be a priority for Mr. Vial to address. I'm going to order $1,000 cash, pretrial services, or drug monitoring. I'm going to order that Mr. Vial's not to be released until he can be connected with pretrial services. And this is Mr. Vial, I understand this is a big order, but you're too important to lose. Okay, what's alleged in this complaint, you know, some people may not consider it violent. It looks like there was you were in harm, given what's alleged. I don't know if what's alleged is true or not, but it's the information I have to act on, okay? I want you to be around for a long time. You have something to contribute to this community, all right? So what I can tell from what the record is, it looks like you've got some work to do. I want you to do that work, okay? I want you to stick around for a while. All right, so that's why I'm ordering what I'm ordering, okay?
I don't plan on using those. I get out, you know, I do plan on going to like Canadian and stuff.
Okay, well, that's a good plan, but I want to make sure that there's something robust in place, okay? So I'd encourage you to,
Wait, $1,000.
yeah, I would,
It's a lot.
yep, and so I want to caution you because these hearings are recorded. So anything you say could be used against you. So if you need a moment to speak with your attorney, that's fine. I can give you that time. But I want you to understand why I'm making the order the way I am now. I'm also going to order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. This is a felony level offense. Will the time limits for the prelim be kept or waived?
They will not be waived. Thank you.
Okay, so we'll keep the time limits in place then, and we are adjourned. Thank you, sir.
Next is Herman Hatch.
You say it's an interest one?
Yeah. I have to control that. Very good. Herman.
I don't want to make the same mistake twice today.
What's your name, sir? Hatch. Hatch, thank you. This is the state of Wisconsin versus Herman Hatch. 25 CF 2654. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Herman Hatch appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. One moment, please. We can confirm that the mailing address on it is correct. We would stand mute as to any misdemeanor charges, waive formal reading of the complaint, and I can confirm at this time Mr. Hatch is eligible for public defender services.
So you have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They're gonna look to get somebody appointed to your case. That's a process that could take a few weeks. It could also take a few months, okay? So just hang in there.
I would also, I've checked the complaint very closely this time, and I would at the very least ask the court to take a look. And I'll do it in the form of moving to dismiss the domestic abuse enhancement. The language in the complaint is awfully thin as it relates to a qualifying domestic relationship between Mr. Hatch and the alleged victim. I don't see any facts that directly state that they do reside together, formally reside together, or have any children together. And what I would just point to, the most that's alleged in the complaint, and I'll obviously leave it up to the court whether this is sufficient. On page 5, it states at the beginning of the paragraph that says domestic.
And any response from the state?
Just one second. I have to read it to you, Your Honor.
Yep.
Your Honor, I'm not finding, I mean, I'm finding exactly what defense pointed to, which I believe is sufficient, right? In the count 1 and count 2, it does, and count 3 and count 4, it does allege that this is a qualifying relationship between these two parties, between Sharon and the defendant. It cites to the statute, puts him on notice. It is a notice pleading state. And then on page, I believe it's 5, it said that, where'd it go? Domestic, Officer Lyric reports that she told Sharon that since she and the defendant had a domestic relationship, Officer Lyric had to press domestic charges on the defendant for the incident. He's on notice that he has a domestic relationship, and I mean, while individuals familiar with these complaints know it's likely a dating relationship or a former dating relationship. It frankly doesn't matter as to the charge. We have alleged that he had a statutory domestic relationship with Sharon, and so be it. He's on notice that we will seek that enhancer. I don't think we have to detail exactly how that domestic relationship is formed. I'm further feel comfortable given the reference to the bail jumping charge in here. And if we pull up that case, no doubt he's also charged as a domestic, with the domestic enhancer in that case as well, with presumably perhaps more detailed language. But regardless, it doesn't matter. He's on notice that he had a domestic relationship. We don't have to spell it out exactly how he had a domestic relationship. And perhaps sometimes we make the decision not to keep from identifying a victim with exceedingly personal details.
Alrighty, thank you. So I'm looking at paragraph, I'm on page 4 of 7 of document 2, that's charging document. There's a paragraph right above the section entitled injuries. It begins, Officer Lyric reports that. That paragraph details that the defendant and the victim were alleged to have been living together at a Kennedy Heights address. So I do believe the complaint establishes a domestic relationship. Attorney Ventola, do you see that paragraph?
What page is that? Oh.
Answer your question about dismissal?
Page 4 is the paragraph above the header injuries.
I do see that. Thank you.
Do you have any response then?
No.
Then I'll deny the motion to dismiss. Find probable cause in the complaint. What are the state's recommendations?
The state's asking for $3,000 cash bond, no contact with Sharon F., no alcohol. The defendant was out on bail with a no contact and a no drink order when this happened. I would also note these are Act 3 charges. This was a particularly brutal attack. The victim had cuts, bumps, and bruises all over her body. She was barely able to walk to the ambulance when law enforcement arrived. Given the severity of the offense, cash is necessary to protect the public and specifically this victim.
All right.
And I would note that the victim's in support of these recommendations.
On behalf of Mr. Hitch.
Sorry, one more second, please.
Yep.
Would be asking for a signature bond or in the alternative, minimal cash bail. It's my understanding that Mr. Hatch, based on his eligibility for public defender services, he is indigent. He does not have $3,000 cash to post. He does have a 12-year-old who lives with him. He's been here in Wisconsin for the last 20 years. I have a note, he's got parents, siblings, extended family, and friends all in the Dane County area. He has also been relatively recently employed at a nursing home, it appears. He does appear to have pretty extensive ties to the community. $3,000 is a pretty significant amount for him to be able to, or to have to post. I would also note, he and I, talked beforehand. When I say beforehand, sorry, I mean earlier during this hearing. And you know, he expressed a strong desire to get out on some kind of monitoring, possibly a curfew. I would leave it up to the court's discretion what appropriate hours would be, and GPS monitoring, if that would tip the scales in favor of his release. You know, he even floated, you know, the primarily home confinement and GPS monitoring, although I would not ask the court to go that far, just to assure his release. Although given, you know, the holidays coming up and the ability to see his family, you know, he's expressed that he's willing to accept some pretty restrictive conditions if it means that he'll be released. And $3,000, as I said, is not an amount that he can post.
Any response from the state?
Your Honor, I think the victim should be able to enjoy the holidays as well. The defendant clearly committed a substantial battery against her after being told to have no contact with her. I think $3,000 is more than appropriate.
We're in Act 3 territory, correct?
We are.
Yeah, I'm hesitating, not hesitating, I'm struggling to find a good reason to not order what the state's recommending. Mr. Hatch was alleged to have been, not only violating his bail by breaking the law, by drinking, but by having contact with somebody he was not supposed to have contact with. I think what can often get missed is sometimes these conditions of bail can help defendants avoid charges. That's not the purpose of bail, obviously, but they're being followed. Sometimes other things can get avoided.
Judge, may I just add a couple other things briefly? I have just looked at his criminal history on CCAP, and I'm not seeing a significant criminal history. I understand that he does have a number of open cases, but just in his history, I'm looking at disorderly conduct, a deferred prosecution disposition on one case, so ultimately everything dismissed, and possession of THC. It appears, and I know the state will correct me if I'm wrong, it appears that his most recent conviction was 2017. We have nothing in 8 years. There are some pretty significant non-monetary conditions that the court could impose to both ensure the safety of the community and the safety of the alleged victim. It does also seem there is a note when the alleged victim chose not to enforce the 72-hour no contact. She made a remark about moving out of state. So I think even if he's just confined to Dane County, that would likely assuage a lot of the concerns about, you know, possible harm to the alleged victim.
Right. I think your point stands, but it's also true that, you know, he was under a bail order at the time of this offense. So, you know, I understand that there hasn't been a conviction since 2017, but now the charges are starting to stack, which gives me great concern, especially just because the research is so clear that victims on types of cases like this, just the chance of lethality is for them is just so much statistically higher, so much greater. So I'm going to order $3,000 cash. I'll order no contact with Sharon F. And I'll order that Mr. Hatch not use or possess any alcohol. No contact means no contact in person, electronically, through a third party, by telephone, by email. No contact means no contact, all right? I'll enter not guilty pleas as to counts 2 through 4. In regards to the time limits for the preliminary hearing for count 1.
Just one moment, please. Thank you.
Yep. Can you call me, pretty please, sorry, pretty please. I mean, I can't help but hesitate to hear that. It sounded like, Mr. Hatch said he wanted to contact somebody and this was the only way.
Not the
I
alleged
don't-
victim, just to be very
I
clear.
don't know who he was talking about, but I would say,
You know, Mr.
I just, I really hope you're not trying to contact the victim in my courtroom.
He is not.
And
He's
I
made
really
that very
hope
clear.
It's not through a third party, because we just discussed, right, that no contact me includes contact through a third party. Okay,
You understand it, absolutely.
very good.
That definitely not there.
We will not be waiving time limits. Thank you.
Okay, we'll keep the time limits in place then, and we are adjourned. Thank you.
Actually, this register, please. Samad Rashid-LAIS, appearing via Zoom.
Oh,
Lace, LAIS.
Oh.
Sorry, thank you under Rashid.
I have Gabriel Rashid-LAIS.
Yep.
Yes.
That's the one I have. Okay.
We had started this hearing on Friday.
Oh. This is the state of Wisconsin versus Gabriel Rashid-LAIS, 25 CF 2648. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Gabriel Rashid-LAIS appears by Zoom from, I believe, the City County Building, alongside Attorney C. Joseph Ventola appearing in person. I can no longer see him on the screen.
The rest of the residents in that housing unit are currently screaming,
Okay,
creating a very difficult situation.
all right. Could we adjourn the this hearing until, would it be better to have Mr. Lace go at the end or rearrange that way?
Mr. Rashid-LAIS is sitting on cash bail right now. I think our intention on Friday is going to be booked in on these charges, but I don't see that that's happened. I'm not sure based on the posture of his other case, if we even need to have his participation today in this. I suppose that's up to the attorneys.
I don't feel comfortable waiving his appearance, but what I will say is if for some reason we're ultimately not able to hold this hearing, Mr. Rashid-LAIS, as has been noted, he's got multiple thousands of dollars of cash bail on other cases. I believe he's been in the Dane County Jail for about 2 months now. If we have to set this over, we can. It's not going to affect his release.
All right, I believe I saw Mr. Lace. Can we get a thumbs up if Mr. Lace can hear us? Okay, I see the bailiff.
The bailiff has just informed me 2 conditions. There's no way that he could hear because of the volume of all the other screaming residents. And he said he does not wish to participate. He's not going to participate.
Okay. So. Not going to, or I don't understand what that means. Does that mean he's waiving his appearance or?
You know, I will say, just based on what I'm able to see from his other open cases, and based off of the snippets of his behavior that I observed on the Zoom video camera, I would be raising competency on Mr. Rashid-LAIS. It appears that it's been raised on his other open cases as well.
The bailiff advised me that he could resident, you can't swear in at the bailiff. That was the only thing that was communicated.
Okay. So Attorney Ventola, how would you like to proceed today?
You know, I don't feel comfortable making arguments on his behalf when I mean, I've been given no advance information about Mr. Rashid-LAIS other than what I was able to see on his court record. I don't feel comfortable making arguments on his behalf. But again, just based on what I was able to observe, based on what I've heard, and based on his court record on his other cases where competency has been raised, I would raise competency. Perhaps we could set this over. I don't know if that would make a significant difference. Although I have no idea what the state is gonna recommend for bail, but he's not getting out one way or another.
And how would the state like to proceed? You don't have to get into your arguments, just how would you like to proceed?
Well, clearly, defense felt necessary to raise competency. We don't take a position on that. We do think the court could set bond. We'd ask for $1,000.
Okay, so what we'll do is, I don't know if this is because of the conditions, but it sounds like the bailiff's office was attempting to facilitate Mr. Lace's appearance. He was swearing at them, weren't able to accomplish the, there was communication via the bailiff's radio, which is not on the record. But the report from the jail where Mr. Lace is appearing is that it's very loud. But the bailiff's been able to communicate. And you weren't able to speak with Mr. Lace at all before the hearing today. Do you have his position?
I got nothing.
Okay. Will the bailiff's office be able to secure his? Let's see here.
I guess I'll say I'm aware that he has an attorney.
Let's take this, Charles Burrow, who's appointed by your office.
Yes. Maybe.
So you wanted to adjourn again?
I think it might be appropriate to adjourn, and if there's some way that we could perhaps notify Mr. Rashid-LAIS's appointed attorney, he might have better luck kind of getting through.
We'll adjourn again. Hopefully, I don't know who's set to appear for the public defender tomorrow, but if they could have contact with Mr. Lace, get his position, and then if we do have these types of issues again, they would at least be able to put on the record Mr. Lace's position on the hearing. So we'll adjourn this hearing.
Next is Luis Rodriguez Sanchez.
Rodriguez Sanchez.
This is the state of Wisconsin versus Luis Rodriguez Sanchez, 25 CF 2658. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Luis Rodriguez Sanchez appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. One moment. I can confirm that the mailing address on it is correct. We would waive formal reading of the complaint. And I can confirm at this time that Mr. Rodriguez Sanchez is eligible for public defender services.
So you have the right to have an attorney represent you at a hearing like this, sir. You are eligible for a public defender. They're gonna work on getting somebody appointed to your case. It's a process that could take a few weeks, could also take a few months. So just hang in there. I find probable cause in the complaint. What are the state's recommendations?
We're asking for a signature bond with the non-monetary conditions not to operate a motor vehicle with any alcohol in his system and not to operate a motor vehicle without a valid driver's license.
No objections to any of the conditions. Thank you.
Then I will enter a signature bond. The condition that you not operate a motor vehicle with any alcohol in your system and that you not operate a motor vehicle without a valid driver's license. This is a felony, so you have a right to have the preliminary hearing within a certain amount of time. You like to keep the time limits for the prelim or waive those time limits?
He will waive time limits.
Okay, we'll waive the time limits then, and we are adjourned. Thank you.
This way, sir. Next is OLAJUWON Burton.
Is that what's left still?
Yeah.
This is the state of Wisconsin versus OLAJUWON Burton, 25 CM 2802. Can I have appearances, please?
Casey Dice appears for the state.
Mr. OLAJUWON Burton appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading, stand mute as to any misdemeanor charges. I can also confirm that the address on it is correct. I have a note here that he does not want to be represented by the State Public Defender's Office. I will just, one moment, please. But he is fine with me representing him for today.
You said you don't want to be represented by the public defender. Do you mind if we give you the information for how to contact the public defender? That way you have it in case you change your mind. Okay. Because there's different ways to get an attorney or to represent yourself if you're competent to do so. But this is most people want to get an attorney and get the case moving along right away. So you'll at least have that option open to you, okay? And you have the right to have an attorney represent you on a case like this, regardless of your ability to pay. I find probable cause in the complaint. What are the state's recommendations?
The state's asking for $250 cash, no contact with LTW. The defendant was just here Thursday, November 20th, on a different case. And on that case, they said, don't contact LTW. And here's a signature bond. And at 4 o'clock in the afternoon, that's when they went through. And then he gets the signature bond, he gets out of jail, and he immediately is contacting LTW contrary to the court's orders. I don't think we need a ton of cash, but clearly signature bonds aren't working. So we'd ask for $250.
Very good.
We do not object to any of the conditions, including the cash. Thank you.
Then I'll order $250 cash. I'll order that. Mr. Burton, you have no contact with LTW. I assume after reviewing this complaint with your attorney, there were, you needed information on how to get property back and not violate the no contact. You have that information now, okay? That's my assumption. I'll enter not guilty pleas on your behalf. And we are adjourned. Thank you.
Thank you.
Next is Michael Gibson.
Stigma. Great. What was that?
This is the state of Wisconsin versus Michael Gibson, 25 CM 2800. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Michael Gibson appears in person and in custody alongside Attorney C. Joseph Antola from the State Public Defender's Office. One moment. We have received a copy of the criminal complaint. We would waive its formal reading, stand mute as to any misdemeanor charges. I can confirm that the mailing address on the complaint is correct, and it would appear at this time Mr. Gibson is eligible for public defender services.
All right. You have the right to have an attorney represent you on a case like this. I noticed you have something in your ears. Can you hear me all right?
Yeah, it helps me hear you better.
Okay, good. I just want to make sure you're able to hear me. You have the right to have an attorney represent you on a case like this. You're eligible for a public defender. You don't already have an attorney appointed through a separate case. They'll work on getting somebody appointed to you. Sometimes that process can take a few weeks. Sometimes it can take a few months. So just hang in there, all right? I find probable cause in the complaint. What are the state's recommendations?
Well, I'm looking at the address. What the address on the complaint is what he intends to use.
Yes.
Alright, so we're asking for a signature bond, but we're asking for a ban from the 3900 block of Lean Road where the victim resides.
And is that it for the state's conditions?
I mean, we should probably have it's not listed, but we should have a no contact with MTD. And my notes indicate MTB reports that the property manager at the complex says the defendant is not on the lease there and is banned. So regardless of what we say, the property manager says he is not welcome at that address.
All right. Okay, but told.
Not going to object to any of the non-monetary conditions. It was my understanding from Mr. Gibson that the address on Lean Road was, I believe he said it was his brother's address, and then he wanted to receive mail there. But he has no problems with the state's conditions. He would actually just prefer to use a different mailing address. I'll let him share that with the court.
Okay, and what's your updated mailing address?
1859 Aberg Ave, apartment 322.
1859 Aber, 322. Do you know the zip code? Is that 04?
53704, I think.
04, okay. So we'll get that address updated in our system. I'll order a signature bond with the condition that you're banned from the 3900 block of Lean Road and you're to have no contact with MTD. I will enter a not guilty plea on your behalf and we are adjourned. Thank you.
Next is Ashan Briggs.
I'll be right back. Sorry. Thank you. This is the state of Wisconsin versus Ashawn Briggs, 25 CF 2657. Can I have appearances, please?
Casey Dice appears for the state.
Mr. Ashawn Briggs appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct, and it would appear that he is eligible for public defender services. Right.
So you have the right to have an attorney represent you in a case like this. You're eligible for the public defender. They should get somebody appointed on your case. Hopefully soon within a few weeks, but it's a process that can take a few months, okay? So just hang in there. I find probable cause of the complaint. What are the state's recommendations?
The state's asking for $1,000 cash, not to operate a motor vehicle and not to operate a motor vehicle. Well, sorry, just not to operate a motor vehicle. As far as the charges go, fleeing is one of those crimes that are highly dangerous. There's claims that a gun was pointed prior to the fleeing. Yeah, he literally attempted to avoid capture from law enforcement by driving at a high rate of speed. That indicates somebody who will not likely return to court absent some sort of incentive to do so.
All right. Attorney Ventola?
You know, I believe that what is really indicative of whether someone will appear in court is their appearance history. Now, Mr. Briggs does not have an extensive criminal history, not that I was able to find. What I see is that he has had one prior case that was 23 CF 634. He made every single one of his appearances on a signature bond. And that's what we're going to be asking for today, a signature bond. I know that the court definitely gets a little nervous with charges of this nature, whether, you know, that indicates that someone might not come to court. But, you know, Mr. Briggs has shown that when he's facing serious charges, he does make his appearances and he can do so on a signature bond. He has significant ties to the community. He's lived here in Dane County his entire life. He's got, from what I can tell, just about his entire family here. He's got two children, ages 5 months and 6 years old, who both live with him. And, you know, for the script, I mean, he is indigent, so $1,000 is a very significant amount of money that he's just not going to be able to post. Given his fairly thin criminal history, given that he has made his appearances on serious charges when it's been required, and given his really extensive ties to the community, I do believe a signature bond is going to be appropriate.
Okay, any response from the state?
No.
All right. I'm going to order $250 cash. I'm going to order that you not operate a motor vehicle. Speeds were alleged to have been over 100 miles per hour. Those are speeds that could mean you don't see your kids or somebody else doesn't get to see their kids because of a pretty serious car accident. At that speed, it's likely going to be lethal for somebody, okay? You know, I understand there were allegations of mitigated mens rea for why there was this fleeing behavior. And I understand, you know, the fleeing behavior is just allegations at this point. But I do believe some cash is appropriate. Just given the allegations. This is a felony, so you have the right to have a preliminary hearing within a certain amount of time. Will that time limit be kept or waived?
We will not be waiving time limits. Thank you.
Okay, we will keep the time limits in place then, and we are adjourned. Thank you.
Next is Michael Chapman.
This is the state of Wisconsin versus Michael Chapman, 25 CF 2652. Can I have appearances, please?
Casey Dice appears for the state.
Just one more moment, please.
Very good.
Mr. Michael Chapman appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. We would waive its formal reading. Mr. Chapman has expressed, he does appear to have a probation hold. And so for the time being, at least, he would like his mailing address set to the Dane County Jail. And we would stand mute as to any misdemeanor charges. Thank you.
Did you say Mr. Chapman is eligible for a public defender?
He is eligible for a public defender, yes.
So you have the right to have an attorney represent you on a case like this. You're eligible for a public defender. They'll work on getting somebody appointed to your case, okay? I find probable cause in the complaint. What are the state's recommendations?
Signature bond, no drugs.
Mr. Chapman has actually expressed, just given the situation with his probation, that he prefers to have a small amount of cash imposed on this case. I'm not going to specifically object to the state's request of the signature bond. I'll leave it in the discretion of the court. But
Part of the reason for that might be getting credit for time served.
yes. So he would ask for a small amount of cash. Actually, one more moment. $50 to $100.
Any response to the state?
$500 is fine.
All right, so I'll order $250 cash. I'll order that Mr. Chapman not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'll enter not guilty pleas to counts 2 and 3. Count 1 is a felony. You're entitled to have a preliminary hearing within a set amount of time. Will the time limits for that preliminary hearing be kept or waived?
We will not be waiving time limits. Thank you.
All right, we'll keep the time limits in place then, and we are adjourned. Thank you.
Next is Jessica Clevenger.
I don't think that's how it works. I think he'd get you out. Yeah.
There is a weird rule about it.
This is the state of Wisconsin versus Jessica Clevenger, 25 CF 2653. Can I have appearances, please?
Casey Dice appears for the state.
Okay. Miss Jessica Clevenger appears in person and in custody alongside attorney C. Joseph Antola. We have received a copy of the criminal complaint. We would waive its formal reading. There is a better mailing address for her. I have it as 111 East Franklin Street, number 1, Portage, Wisconsin, 53901. We would stand mute as to any misdemeanor charges, and it would appear that she is eligible for a public defender. I believe that she's being represented by an attorney in our office on one of her open cases.
Very good. So you have the right to have an attorney represent you on this case. You're eligible for a public defender. You have one appointed in another case. So they should just appoint that other person to this case, all right? It might not happen if there's a conflict or something like that, but usually that's what happens. I find probable cause in the complaint. What are the state's recommendations?
We're asking for $500 cash and no contact with any Target store. The defendant, these aren't the most serious charges in the world, or the allegation as to what she was doing. The issue is when she was doing this theft, she had 4 open cases in Columbia County, and this is now her second open case in Dane County. Clearly, signature bonds and whatever she posted previously isn't working. We're just in the situation where we just need to have progressive cash, and at some point, there will be a financial incentive for her that's enough to get her to stop doing these crimes.
Response?
We would be asking that cash bail be set in the amount of $250. We understand the state's concerns. I would just emphasize, Ms. Clevenger has lived in Wisconsin for a significant period of time from what I'm able to tell. She has 2 children, aged 7 and 5, who both live with her. Her parents live in Wisconsin. Her siblings live in Wisconsin. She does have significant ties to the community. So I would just ask for a lesser amount of cash bail, $250. Thank you.
Okay, any response from the state?
Nope.
All right, I'll order $375 cash. The condition that Ms. Clevenger, you're not to be at any Target. I'll enter a not guilty plea as to count 2, which is a misdemeanor. Count 1 is a felony. Ms. Clevenger, you have the right to have a preliminary hearing within a certain amount of time. Will the time limits for that preliminary hearing be kept or waived?
We will waive time limits. Thank you.
Okay, we'll waive the time limits then, and we are adjourned. Thank you.
Next is Avery Ness. Avery Ness.
This is the state of Wisconsin versus Avery Ness, 25 CF 2656. Can I have appearances, please?
Casey Dice appears for the state.
Ms. Avery Ness appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct, and it would appear that Ms. Ness is eligible for public defender services.
You have the right to have an attorney represent you in a case like this. You're eligible for a public defender. Hopefully they get somebody, hopefully they find an attorney to accept appointment to your case soon within the next couple of weeks, but sometimes it's a process that can take a few months, okay? So just hang in there. I find probable cause in the complaint. What are the state's recommendations?
Signature bond, no drugs.
No objections to a signature bond. As far as I'm able to tell, Ms. Ness does not have any criminal history. This is a case of simple possession. We're not going to object to the non-monetary conditions either. Thank you.
Okay. Any response to the state?
No.
Okay, I'll order a signature bond with the condition that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. I could order pretrial services to conduct drug monitoring. Do you think that would be helpful to you? You might want to have a conversation with your attorney about that right now. But you can let me know. Do you want me to order that?
Will not be asking for that.
Then I won't order that. I will the time limits be kept or waived?
I'm gonna need 1 minute to explain that to her. Obviously, she doesn't have a criminal history, so this is all very new.
Yep, take your time.
We will waive time limits. Thank you.
Okay, we'll waive the time limits then, and we are adjourned. Thank you.
Next is Degree Blakely. Blakely. Everyone. And
This is the state of Wisconsin versus Desiree Blakely, 25 CM 1638, and Dane County versus Desiree Blakely, 25 FO 2292. Can I have appearances, please?
Casey Dice appears for the state and county.
Ms. Desiree Blakely appears in person and in custody alongside attorney C. Joseph Ventola. I suppose I should just briefly mention I'm only appearing on the criminal matters. I'm not authorized to appear on forfeiture matters. 1 moment, please. We have received I can't speak today. It's been a lot of these appearances. We have received a copy of the criminal complaint. We would waive its formal reading. I can confirm that the address on it is correct. Stand mute as to any misdemeanor charges, and it would appear that Miss Blakely is eligible for public defender services.
All right.
Since the bail hearing on a warrant, it looks like she's got attorney grant.
Okay.
When I had checked CCAP earlier, it appeared that he had withdrawn.
On this case,
Request, but it does show attorney, I haven't seen attorney of record right now in your system.
Okay.
I'll do some further inspection. I guess I note that Ms. Blakely also has a pending extradition case that's 25 CF 1678. She was being held on that warrant body only until maybe an hour or two ago. It looks like the court in that case just set $25 back bill.
And we're past the IA on this case. There was an initial appearance July of this year, 2025. There was a non-appearance in September 2025. A bench warrant was authorized. There was a return on warrant this past Friday, November 21st, 2025. What are the state's recommendations for bail?
I mean, absent the extradition issue, we'd be back in a signature bond posture after, having spent a couple days in jail. I don't know if she would prefer a signature bond or low cash.
I would join in the recommendation for a signature bond. It doesn't appear that Miss Blakely has any criminal convictions. And I don't believe there are any Act 3 eligible offenses here.
Okay, I'll order a signature bond then with the conditions as previously stated, namely that you shall not threaten or direct any acts of physical violence towards Jaden W. or Vincent L. That's JADEN, W as in walrus, and Vincent, VINCENT, L as in Larry. I'll enter a not guilty plea on the forfeiture. And I believe that's all I can do for the parties today. So we are adjourned.
Thank you.
Next is Felicia Williams.
This is the state of Wisconsin versus Kalisha Williams, 24 CM 2175, 24 CM 2176, 25 CF 2663, and 25 CM 512, and 25 CM 1366, and 25 CM 2801. Can I have appearances, please?
Casey Dice appears for the state.
Ms. Kalisha Williams appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaints. We would waive their formal reading. I'm just checking. I don't believe the mailing address is consistent on all of them. And so Ms. Williams has represented that she would like her mail to go to the Beacon, 615 East Washington Avenue. Stand mute as to any misdemeanor charges. And I can confirm that she is eligible for public defender services. It appears that she has a private attorney appointed through the public defender's office currently.
So you have the right to have an attorney represent you on these cases. Looks like you have a public defender assigned. You should get that same person assigned to the newer cases. All right, and it looks like we're here for bail bonds hearing and new case, first appearance in 25 CM 2801, 25 CF 2663. I find probable cause in those complaints. What are the state's recommendations?
Sure. For the new case 25 CF 2663, state's asking for $1,000 cash, no use or possession of controlled substances or drug paraphernalia without a valid prescription. The defendant was recently on a bench warrant for about 3 months. In our 4 pending cases, cash is necessary and appropriate. In 25 CM 2801, in that case, the charging attorney would be satisfied with a signature bond, a ban from the 300 block of Clyde Gallagher Avenue in Madison. As for the other ones, the 4 other cases here on bond return or on return on warrant, 4, correct? 4 return on warrant? Yes. That's for reinstatement of all non-monetary conditions. She has had, it looks like, the benefit of signature bonds for most of her prior bond history, with I think just once did I see that bond was set at $150 in one case back in June. It doesn't indicate that she was able to post it, and then shortly thereafter, I imagine bond was reduced. It was, she certainly does not have a demonstrated history of being able to post cash bond, but also when given signature bonds, she has a demonstrated history of not returning to court. It's a bit of a catch-22. I'd note bench warrants from, of course, September 8th of 25, in which she was out until arrested on these new cases. She also had a bench warrant in May of 25, February of 25, January of 25, April of 23, February of 23. It's unfortunate. I recognize that she's likely homeless, likely doesn't have a lot of means. The issue is when given a signature bond, she frequently doesn't come back to court, and these cases just get older and older. So I do think maybe $100 on each of those cases as well.
And Attorney Ventola?
Just 1 minute, please. Thank you.
Very good.
I understand that just given the posture of this case, given the history here, that the court is likely to impose some amount of cash. I don't have to go through Ms. Williams's history. I think the state did it quite well. She has a demonstrated inability to pay. She told me that she probably couldn't post more than maybe $50 or $60. I do think the court's likely going to be looking at an amount higher than that. You know, I would ask maybe $100 on each of the open cases. Ms. Williams has lived here in Dane County her whole life. She does have extensive ties to the community, but she has been deemed indigent. She is getting her mail at the Beacon. You know, $1,000 is going to be prohibitively expensive for her. Just given that, I would ask for consideration of ask for consideration of that, and having gone through these complaints, it seems that, you know, a common theme is possible addiction issues, possible mental health, and, you know, it's significant cash, and holding her in custody pre-trial may not necessarily be the best, most supportive environment for her. So I would just ask the court to consider those factors when imposing cash. Again, maybe no more than $100 per case.
And any response from the state, including whether pretrial services would be a suitable alternative in lieu of cash for Ms. Williams?
I mean, her big issue is not coming back to court. I'm not sure if the bracelet or if the urinalysis or I'm not sure if that would facilitate that issue. So I think we're just in a cash situation.
You know, I will mention, Miss Williams has told me that she'd be willing to do the bracelet. I do think the bracelet at least helps if her whereabouts are being monitored. And at the very least, there's kind of that awareness that you can't run, you can't hide, they're gonna find you, right? And she also said that she's on any of the cases she said previously, she's never been offered the opportunity to do the bracelet. So she's open to doing the bracelet. If the court is willing to consider that as an alternative to cash bail, then I think that would be preferable here. Thank you.
Well, drug monitoring wouldn't occur via a bracelet. I think that would require her physical appearance to drop a sample. Isn't that correct? Are you talking about?
When you said pretrial services, were you referring,
I was referring to
apologize.
drug monitoring and referral services. I wasn't clear. That's my fault.
Okay, I apologize. I had assumed that it was GPS monitoring, which again, Ms. Williams is open to. I'll ask her about, you know. Ms. Williams has expressed that she is open to drug testing.
Okay. Then in 25 CF 2663, I'm going to order a signature bond with the condition that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'll order that you're not to be released except at a time when pretrial services is open and able to receive clients. That likely won't be today, ma'am, just so you're aware. And then in 25 CM 2801, I'm going to order a signature bond. The ban from the 300 block of Clyde Gallagher Avenue. I'll also order pretrial services for drug monitoring in that case. At the same time of release, only when pretrial services is open and can receive clients. So, ma'am, once you're released, you're to immediately report to pretrial services and connect with them, okay? All right. They'll conduct drug monitoring. They can also handle referrals for services. So if you need extra help quitting, like a therapist or something like that, they can work with you to try to figure out an appropriate service for you, okay? I will enter not guilty pleas as to any felonies.
Not guilty pleas as to any misdemeanors.
Yes.
The rest of the cases that we have.
We'll have the same non-monetary conditions.
As fire, except also with the pretrial services and the drug monitor.
I don't think we need to order that to get it. Is it gonna be a pain to do that with all the cases? Or will it be a distinction without a difference if we don't
It makes
keep it
a
at them?
difference.
What's your, okay, let's just have it all matched then.
So all of the cases, referral pretrial services with drug monitoring, and cases that don't have an underlying condition, you're at,
Yes, please. And then all other non-monetary conditions on those cases will remain the same.
yes.
There's a felony case, count one on 25 CF 2663. That still needs a prelim. Will the time limit for that prelim be kept or waived?
Kept, thank you.
We'll keep the time limit in place for that case then. I believe I covered all the bases we needed to. Attorney Dice, is that your analysis as well?
Does she have an attorney?
Yes.
That's fine then.
You have a right to have an attorney represent you on cases like this. And Attorney Ventola, from your perspective, did I cover everything?
I believe so, yes, thank you.
Very good. Then we are adjourned. Thank you, madam.
Next is Nicole Nelson.
This is the state of Wisconsin versus Nicole Nelson, 25 CF 2664. Can I have appearances, please?
Casey Dice appears for the state.
Ms. Nicole Nelson appears in person and in custody alongside attorney C. Joseph Ventola. We have received a copy of the criminal complaint. We would waive its formal reading. One moment, please. I can confirm that the mailing address on it is correct. While it appears that her eligibility for a public defender has not been confirmed on this newest case, it does appear that she has a public defender appointed on one of her other open cases.
So you have the right to have an attorney represent you on a case like this. You are eligible for a public defender. If you have another public defender appointed in this county on a separate case, that same person should get appointed to this one. If you don't, it's a process that can take a few weeks to a few months to get an attorney to accept appointment to your case. So just hang in there, all right, ma'am? All right. I'm just gonna take a look at the complaint quick.
This complaint did come in a bit after we started our afternoon scale.
All right.
Pretty good bullet for when we get to it, Ms. Nelson already has a prelim scheduled on December 2nd, which would be within the timeline to report over some case, so probably the 7th right along.
That works.
Find probable cause in the complaint. What are the state's recommendations?
Your Honor, the state's asking for $2,000 cash, not to operate a motor vehicle, no use or possession of controlled substance or drug paraphernalia without valid prescription. Cash seems to be appropriate here to ensure both future court appearances as well as following the court's orders. And she now has multiple pending cases. She also has a different OWI pending aside from this one. She is currently in Dane County pretrial services, right? She was actively enrolled in Dane County pretrial services when she, possessed drugs and possessed methamphetamine, possessed narcotic drugs, drove under the influence again, and bail jumped. Clearly, that has been exhausted. This incident occurred at around 4 a.m. or 4 p.m. She ended up going to the ICU after being administered Narcan multiple times. A bench warrant was issued for the October 17th non-appearance for a pretrial conference. Again, at this point, we've exhausted all the softer approaches, the Dane County pretrial services, the do this good thing, do that good thing. We're just in cash now, cash and don't drive. And so $2,000 cash, don't drive, don't do drugs.
Okay. Any Vento?
Sorry, I mean, I'm sure as this court's aware, Ms. Nelson's case was kind of added to IA's a little late today, so I was just getting some background information on Ms. Nelson. I didn't have anything.
No worries.
Yep, so I'm going to be asking for a signature bond on this case. So it's my understanding that she was just recently revoked. She waived her revocation hearing. She's waiting her sentencing after revocation. And her hope, of course, was that she would be able to serve whatever the imposed jail sentence is on diversion. If she's able to do that, that would involve not insignificant monitoring by the Dane County Jail. And if she, for whatever reason, does not end up getting out on diversion, she'll be sitting in the Dane County Jail whether there's cash imposed on this case or not. I talked to her, and what I was able to get from her was that she has lived here in Dane County for her entire life. The whole of her family resides in Wisconsin. She has an apartment that she leases in her name. She has worked here in Dane County for, I believe, she's worked in Dane County her whole life. Her ties to the community are pretty extensive. Given the, let's say, other avenues for monitoring her, I do think a signature bond would be appropriate because, again, either she'll be sitting in jail because she can't get out on diversion, or she'll be on diversion. She'll be, on an ankle bracelet. Jail will be monitoring her. I think either or, a signature bond is going to be appropriate here. Thank you.
Okay. Any response from the state?
No, Your Honor.
All right. Yeah, I agree with the state in terms of whether cash is needed. That plan changes due to a diversion plan. Ms. Nelson is certainly welcome to come back to court and ask for that amount to be reduced because there's another plan, but right now that's a little bit too speculative for me to feel comfortable ordering a signature bond. It looks like the probation hold was revoked for sentencing according to my notes. So I'll order $2,000 cash, that Ms. Nelson not operate a motor vehicle, and that she not use or possess any controlled substances or drug paraphernalia without a valid prescription. I'll enter not guilty pleas as the counts 3 through 5. Counts 1 and 2 are felonies. Well, the time limits, I'm sorry, we already addressed that. The time limits will be kept because we already have a prelim set in a separate case. I believe that's all I can do for the parties today, so we are adjourned.
Thank you.
Thank you.
That's our.
And then-
Thank you.